Canada Gazette, Part 1, Volume 158, Number 51. Regulations amending the Immigration and Refugee Protection Regulations, Administrative Penalties and Consequences, 45-day consultation, until February 4, 2025, 11:59 p.m. Eastern Standard Time. December 21, 2024. Statutory Authority Immigration and Refugee Protection Act sponsoring Department of Citizenship and Immigration Regulatory Impact Analysis Statement. This statement is not part of the regulations. Individuals seeking to immigrate to Canada or become Canadian citizens often rely on the advice and expertise of other people to help them navigate immigration and citizenship processes and applications. Individuals committing infractions such as providing advice and representation for remuneration without authorization or counseling fraud and misrepresentation on their clients' applications has a negative effect on the integrity of Canada's immigration and citizenship systems. The impacts on clients can be particularly egregious when the victims are vulnerable due to language and cultural barriers. Under the existing regulatory framework, there are no tools for Immigration, Refugees and Citizenship Canada (IRCC) to sanction individuals who commit these kinds of infractions. Background-only authorized immigration and citizenship practitioners are permitted to provide advice and representation for payment on immigration and citizenship-related matters. Authorized practitioners include members in good standing of one of the following groups: the College of Immigration and Citizenship Consultants, the College, a provincial or territorial law society, or the Chambre de Notaires du Québec. These practitioners are authorized to provide services such as explaining immigration and citizenship options, advising as to the most appropriate programs, assisting in the completion of applications, and communicating with IRCC. Their specialized expertise allows them to help applicants navigate Canada's immigration and citizenship processes and ensure applicants meet the requirements. According to the college's annual report, in 2023 there were 11,750 licensees of the college. All lawyers and Quebec notaries are authorized to provide immigration and citizenship advice and representation, though many practice in other unrelated areas. Authorized practitioners receive specialized training and are effectively regulated, meaning that they are held to a high standard of practice and there are options for complaints and potential recourse through their professional regulators should they not meet those standards. In addition to licensed practitioners, there is an unknown number of unauthorized individuals both in and outside Canada who provide paid advice and representation, despite not being legally permitted to do so. Unauthorized individuals are a problem in the current immigration and citizenship system, and solutions are needed to help deter their actions. For example, an average of 282 leads of suspected consultant offences are brought to the attention of the Canada Border Services Agency (CBSA) annually, and of these, an average of 17%, involve alleged unauthorized individuals. On average, a quarter of charges laid annually are against those who are not authorized to provide immigration and citizenship consultant services. This data represents the 2018-2022 calendar years inclusively. Despite existing professional discipline measures and criminal penalties, clients continue to face issues like fraud in applications and documents. These may have dire consequences for applicants, including refusal of citizenship or immigration applications, financial hardship, and losing legal immigration status in Canada. In June 2017, the House of Commons Standing Committee on Citizenship and Immigration (CIMM) published a report entitled Starting Again: Improving Government Oversight of Immigration Consultants. CIMM studied the framework governing immigration and citizenship consultants and found it inadequate. The committee made 21 recommendations focusing on 3 areas of concern: 1. Weakness in governance, 2. Insufficient resources for investigations and enforcement, and 3. Lack of public awareness and the need to better serve clients. In response to these persistent issues and the CIMM recommendations, the Immigration and Refugee Protection Act (IRPA) and the Citizenship Act were amended in 2019 to allow the establishment of an Administrative Penalties and Consequences (APC) regime by regulation. This initiative aims to address the observed gaps by enabling IRCC to directly respond to and sanction those who commit violations while providing paid immigration and citizenship advice. Proposed amendments to the Immigration, Refugees and Protection Regulations (IRPR) and the Citizenship Regulations (CR) are crucial steps towards enhancing the integrity of the immigration system and more effectively safeguarding the interests of those seeking to navigate it. Objective: the proposed regulatory amendments would provide more oversight and accountability for authorized immigration and citizenship practitioners and unauthorized individuals by providing an additional enforcement tool. Encourage compliance by those who provide immigration and citizenship services with the provisions of the IRPA and the CA and these proposed regulations. And protect immigration and citizenship applicants from harmful situations, such as receiving fraudulent or unauthorized advice and representation. The expected outcomes of the proposed amendments are to decrease fraudulent applications by deterring those who provide immigration and citizenship services from committing or counseling misrepresentation and informing the public of individuals who have committed violations. Decrease the number of applications involving unauthorized individuals and increase public confidence in the regulation of licensed practitioners. Description: the proposed regulatory amendments below would be made to both the IRPR and the CR violations. The proposed regulations would prohibit a person from providing or offering to provide representation for payment unless they are authorized to do so under the CA or IRPA. The proposed regulations would prohibit a person who represents or advises someone for payment from misrepresenting or withholding information, advising them to misrepresent or withhold information, or communicating misleading information. Proposed amendments would designate unauthorized practice and misrepresentation as violations. Inspections: the proposed regulatory amendments would provide IRCC officers the authority to require in writing that a person or entity provide any relevant documents to verify compliance in circumstances where the officer has reasonable grounds to believe they have committed a violation. If the individual fails to submit relevant documents, the failure would be justified if the individual made reasonable efforts to comply. Notice of preliminary findings: under the proposed regulations, an IRCC officer who has reasonable grounds to believe that a person committed a violation would have the authority to issue a Notice of Preliminary Finding, NOPF. Under the proposed regulations, the notice would be required to include the name of the person who is believed to have committed the violation or violations, the relevant facts and provisions with respect to each violation, the preliminary finding and the reasons for the finding, the amount of the administrative monetary penalty for each violation and the total amount of the administrative monetary penalties, the effect, increase or reduction, on the amount of the administrative monetary penalty of any previous notice of violation issued to the person's right to, within 30 days after the date of receipt of the notice, provide information about the relevant facts and the amount of the penalties to IRCC, and the fact that, if the person is found liable for a violation, certain information will be made public. A notice of violation: the proposed amendments would give an IRCC officer the authority to issue a notice of violation, NOV. Following the issuance of an NOPF and after having reviewed any information submitted in response, an officer would have the authority to issue an NOV if they determine on a balance of probabilities that a person committed a violation. The NOV would be required to include the name of the person who is believed to have committed the violation or violations, the relevant facts and provisions with respect to each violation, the determination and the reasons for the determination, the amount of the administrative monetary penalty for each violation, the total amount of the administrative monetary penalties, the effect, increase or reduction, on the amount of the administrative monetary penalty of any previous notice of violation issued to the person, the right of the person to request, within 30 days after the date of receipt of the notice of violation, a review of the facts that constitute the violation or of the amount of the administrative monetary penalty, or of both. The fact that the person must pay the administrative monetary penalty within 30 days after the date of receipt of the notice of violation, unless they request a review or enter into an agreement with the minister with respect to payment within those 30 days. The method of payment for the administrative monetary penalty, and the fact that, if the person is found liable for a violation, their information will be made public. The proposed amendments would also provide that no administrative monetary penalty could be imposed on a person if any acts or omissions occurred prior to the date of issuance of their most recent NOV. Administrative monetary penalties and amounts. The proposed regulatory amendments would introduce a formula and baseline penalty amounts to be used when calculating the administrative monetary penalty for unauthorized practice and misrepresentation. Administrative monetary penalty equals A plus B plus CD, where A is the baseline penalty amount, which would be determined depending on the type of violation. Representation or advice without authorization, $5,000. Misrepresentation. $15,000 billion is the amount added when a misrepresentation violation had an additional impact by inducing an error in the administration of the relevant act by causing an application to be approved when it otherwise would not have been. Additional impact amount, $15,000. C is the financial advantage gained as a result of the violation. If an individual gained a financial advantage as a result of committing a violation, e.g., any money that they were paid by a client to provide unauthorized advice or to assist with misrepresentation, this amount is included in the penalty amount. D considers the individual's previous history with the regime. Specifically, if the person has not previously been issued a notice of violation, the penalty amount would be multiplied by 0.5 halved. If the person has on one previous occasion been issued a notice of violation, the penalty amount would stay the same, multiplied by 1. If the person has been issued a notice of violation on 2 or more previous occasions, the penalty amount would be multiplied by 1.5. Failure to comply with an inspection. The proposed regulations would establish the penalty for an individual who does not comply with a request for submission of relevant documents by an officer to verify compliance at $10,000. Multiplied by the factor in element D of the formula for other violations. A failure to comply on more than one occasion in the course of an inspection would result in 1 administrative monetary penalty. Maximum amount per notice of violation. The proposed regulatory amendments would specify that if a NOPF or a NOV includes multiple violations, penalties are cumulative and the total amount for all violations could not be more than $1,500,000. Payment. The proposed regulations would require that an administrative monetary penalty be paid within 30 days after receipt of the notice of violation, unless the person has entered into an agreement with the minister with respect to payment within 30 days. Review. The proposed regulations would allow a person who received an NOV to make a written request, within 30 days of receipt of the notice, for a review of the facts of the violation or of the amount of the penalty, or both, instead of paying the administrative monetary penalty. As per IRPA and the CA, the review would be conducted by a reviewer appointed by the governor and council for that purpose. The proposed regulations would require that the reviewer determine whether the person was liable for the violation and the amount of the penalty, based on the information that was available to the officer who issued the notice. The proposed regulations would not allow the reviewer to consider new evidence. Based on the findings of their review, the proposed regulations would require the reviewer to cancel, confirm, or amend the notice of violation, and to state in writing the reasons for their decision. The proposed regulations would require that the person pay the penalty set out in the notice of decision within 30 days, unless they enter into an agreement with the minister. Consequences. The proposed amendments would require that the minister publish information concerning persons found liable for a violation on IRCC's website, including their name, the name and address of their business or place of employment if applicable, the date on which a notice of violation was issued to served on the person, the date of the reviewer's decision if applicable, the nature of the violation, the amount of the administrative monetary penalty, and an indication of whether the person has paid the penalty.